Good afternoon, everybody. Welcome to this 40-minute webinar on behalf of both 39 Essex Chambers and Fnatic. This webinar will focus on the legal risks and likely disputes in esports. Fnatic is the professional esports organisation headquartered in London. It's established 15 years ago and has teams playing around the world in a variety of games, including Counter-Strike, Global Offensive, and League of Legends. The Fnatic Counter-Strike team is particularly renowned. My name is Jonathan Bellamy, and I'm a sports law and commercial law barrister from 39 Essex Chambers, where we have a prominent sports law group of counsel and arbitrators. We have 100 plus participants attending today from the UK, Middle East, Russia, and Asia. Participants are from solicitors, in-house counsel, national sports governing bodies, Premier League football clubs, sports agencies, accountants, and sports arbitral institutions. The sports sectors represented demonstrate the range of interest in esports currently and include professional football, athletics, motorsport, sailing, and rowing. The format will be for the four speakers you see, and I will introduce in just a moment, to take part in a round table or perhaps rectangular screen discussion focusing on the topics of contractual issues, data protection, safeguarding, integrity, and dispute resolution. We welcome questions via the chat and Q&A functions at the base of your screens. We may not be able to respond to all your chat questions, but we'll do our best, and we will respond to any unanswered questions after the event by email. This webinar is being recorded and will be available from Friday to be viewed via our homepage on the 39 Essex Chambers website. If you require CPD, the provider is 39 Essex Chambers. So, by way of introduction, our speakers. Andy Cooke is General Counsel at Fnatic, the leading team in esports. Although he qualified as a litigator, Andy subsequently built a career in music and sport. He supported the delivery of entertainment to more than 8 million people, including events for the AFC, FIFA, and the UFC, and artists ranging from Madonna and Metallica to, he says, and of course I believe him, His Holiness Pope Francis. Amelie is trainee counsel at Fnatic. She works with Andy across the business with a particular focus on pro gaming. Amelie joined Fnatic in March 2019. Stephanie David is a barrister at 39 Essex Chambers. She has a growing expertise in sports and esports law, particularly in anti-doping, safeguarding, and sponsorship agreements. I have a litigation arbitration advisory practice in commercial law and sports law. My sports law work covers a range of commercial practice areas in the sports sector, including commercial contracts, insurance, gaming, governance, and disciplinary. I also have an active practice as a chartered arbitrator in the sector, in particular in professional football. So with that introduction, we're going to start by looking at the esports development, the maturity of that sector, and then discuss the ecosystem. So we'll start with Andy and then move on to Amelie.
Hello, everybody. Well, good afternoon, and thanks very much for joining us. I wanted to kick off because I think it's a good framer for what follows with where the esports industry is right now and the developments that it's seen in the last probably 4 years. And really to contextualize that with where the sort of or the impact of the Premier League on football and the impact of professionalisation on rugby. So around sort of 16, 17, you start to see greater level of seed funding in esports. Private equity started to sniff around the opportunities that we have to communicate with young people in particular, and particularly hard to reach young people from a brand and advertising standpoint. So esports is particularly appealing. We know from, for example, Twitch statistics to 16 to 25-year-old young people. Predominantly men in terms of PC gaming, but a significant number of women in mobile gaming, which is certainly an area which is probably the future of pro gaming overall. So that money comes in, the investors in esports starts to change and start to specifically move away from the original founders of esports teams who tended to be gamers themselves. And as I always say in relation to these kind of conversations, it's a healthy reminder for those of us in risk management how far esports was able to get with basically no back office support whatsoever. It does sometimes contextualize the inputs that we put in. So that inflow of cash really came in sort of 17, 18. That inflow wasn't always tracked by equivalent gains in terms of risk management, methodology, approach, personnel, and so on. So what that means is you have quite a lot of poor agreements out there, real classic sort of fails like UK governing law clauses and that kind of thing. This session really isn't about those kind of contracts. It's really more about trend spotting what we see in the future. I would say over time, the issues arising from those will sort of be flushed out and resolved by the system. And we're going to talk about one of those in relation to a particularly famous gamer called Tfue later on. So I talked about the Premier League. You remember that the Premier League's 92-93 season, first deal with Sky was 300 million for 5 seasons. That influx of cash in the game really didn't have a great deal of oversight from the media as a whole. Rugby professionalisation post-World Cup in 95, you're still seeing issues being flushed out by the impact of professionalisation on the game today. Esports, much shorter timeline for that, but a much greater degree of scrutiny from the sort of industry, the world at large, because of course we are the first natively digital sport. Everything we do and every issue that we have is litigated in the highest court in esport, which is of course Twitter, and the attention to these issues that kind of arise is really high. So what is sort of interesting and prurient for esports up front now and I want to really emphasize this, may not be the issues that are relevant in due course. So that's basically where we are in terms of maturity. Amelie is going to walk you through just briefly the sort of key areas of the ecosystem. And we'll try and be quick on this, but if anybody has particular questions in relation to the ecosystem more generally, please do flag them in the Q&A, because we're happy to, it's really important. One of the key things that you have to take away from this session is that the game that you are in is really going to determine what your rights and obligations are and how the various players in the ecosystem are interacting with each other. That's important, particularly if you're coming at this from a brand standpoint. Amelie, do you want to take us through the 4 key elements?
Yeah. Hi, everyone. So for present purposes, there are the 4 key elements of the esports system are the developers, the broadcast platforms, players, and the teams. And we're not going to talk about the fans right now. Steph is going to cover that in the context of integrity issues as well. When she talks about safeguarding. And unless the audience wants us to explore it, we don't plan on peeling off the different layers of the IP involved in games, the use of real life people and sort of their tattoos and dances. So the 4 key elements, we begin with the developers. This all starts with the games themselves, which are owned by the developers who built the game. The developers take a range of approaches on how to exploit their IP, and this is true even at the highest tiers of the game. We see this particularly clearly in the difference between Riot, who own League of Legends, and Valve, who own Counter-Strike. So that Riot takes a very centralized model, it's a very heavily structured ecosystem with regional championships and worlds finals as well, which have Super Bowl sized viewership. And the LEC Spring Split has had 500 million watch hours. And then there's a development league, so the UKLC and the NLC that sits below that. And they control the ecosystem entirely, including the broadcast rights. So they can attach conditions of participation in that ecosystem. So for instance, all of our League of Legends players have to be employees and can only be traded during transfer windows. In contrast to that, there's a very decentralized model for Counter-Strike. Valve is more interested in selling games than running the tournaments. So they have outside league operators come in and fill the need for that structural competitive play. There's several because Valve prohibits exclusivity. We won't cover antitrust or competition other than in the context of employment rights in this, as you can see. Anyway, broadcast platforms are the second on the list of four, with YouTube being the on-demand platform and Twitch being the live stream platform. Twitch has seen a massive increase during the quarantine in particular, with their watched hours topping 1.7 billion in May versus just over 1 billion in January and February. And Andy, jump in here at any point if I'm missing anything, okay?
You're doing great, mate, doing great.
Thanks. And the other statistic that's interesting about Twitch is that their active streamers increased by 3.5 million between February and April this year. The next section are the players. These are dedicated professionals earning millions of dollars each year. We've seen two levels of transition, really. The first being the infusion of cash that Andy talked about earlier, between, in the 2 years prior to 2018. And then the repositioning of players as influencers, which we see with the Twitch hours streamed in May 2016 being 13.4 million versus 24.7 million in May of this year, which prompts the revaluation of players as assets. And being entertaining is emerging as a distinct talent to being good at the games themselves. And then the teams are the next one, with the level of influence depending on how important they are to the game. So League of Legends, Counter-Strike, Rainbow Six, teams in those games have, the team cohesion and communication is critical, versus FIFA and Fortnite, where they're more partnership and entertainment plays, and the top of the funnel in esports terms. So that's a very brief overview.
Yeah, that was a proper sprint. But I think what Amelie has done very successfully there is to bucket up really the key sort of parts of the ecosystem from a team standpoint. And again, depending on who's talking about esports is going to depend on what weight they give to each of those features, if you like. So, for example, from our perspective, obviously we care a lot about the players. We certainly care about the fans. Not in this conversation from a legal rights perspective necessarily, but obviously important to us. I think those two centralized and decentralized models of game development are really that critical point which I mentioned earlier on. If you're in one of those two games, you're really going to have a very different experience as a kind of in terms of mapping the legal rights. So far, the Riot model has been the more successful. I think it's fair to say. If the goal is long-term sort of visibility and predictability in terms of outcome. There are some moves to bring Counter-Strike, which is a very old game, it hasn't really changed very much in 20 years, to bring Counter-Strike more in line with the Riot model. And Fnatic is part of a group of teams that are involved in sort of building that structure out right now. In fact, we were talking about domicile for the relevant it'll most likely be an NBA type model where you have contractual relationships governing the various parties and the rights holder. We were discussing the domicile for that only this afternoon.
That's great. And just before we move on to contractual issues, why is it that Riot has been more successful in your view? The model.
I think because first of all, they were in a position to be. So again, a game that a lot of people have familiarity with, Amelie touched on it just there, is FIFA. EA, which has a similar orientation to Valve in that it basically exists to sell games and then upsell people on microtransactions once they've purchased the games. It has the ecosystem, or it has just the sheer weight as an organization to invest in building the servers and the structures and the kind of, the very well built out legal relationships between the various stakeholders in its monetization opportunity rather than necessarily in the ecosystem as a whole. So even for us, if we want to run a tournament involving an EA game, there will be a community agreement that we have to enter into. And also if I look at, let's say, things like in-game items, the sale of kits and those kind of things, heavy structuring involved, even down to the extent of the insurance requirements, which we need to comply with in order to have a Fnatic branded kit in the FIFA title. Millions and millions of dollars in coverage to have a kit in a game. So you have to be of a certain size to almost bring in that level of structure and a certain willingness to monetize, or let's say a belief, sufficient belief to monetize in the long term. And I think Riot's investment up front would have been absolutely substantial. Not everyone wants to make that investment, I guess, is the main outcome.
Thanks, Andy. Well, we move on to talk about some contractual issues which are likely to emerge. One of the points which seems likely to us is disputes, firstly, as Andy already mentioned, about badly drafted historic agreements. It's not unusual in sports, not just esports, but where agreements can be done, important agreements that may not seem very important at the time, become important over the course of time, particularly where athletes become prominent. Sponsorship agreements are an example. Terms in sponsorship agreements, restraint of trade provisions, the presence or absence of force majeure clauses. Esports, of course, is one of those areas, one of those few areas that has not suffered as a result of the recent COVID situation and lockdown. Indeed, Andy can probably give you some statistics that would really impress any professional sporting body to say how the involvement of esports, perhaps unsurprisingly given the nature of lockdown, has increased the contribution and attendance levels. So sponsorship agreements are going to be an area. Badly drafted agreements are going to be an area. My prediction would be that the development of good faith in contracts, more generally in commercial contract, particularly in what we're now describing as relational contracts, will become very important in esports. Whether or not there are ups or down times in the market, negotiations for extensions of term, clauses that perhaps include aspirational agreements to agree that are not legally enforceable will have to be considered. And also, of course, dispute resolution clauses. Now, Andy, you've had a lot of experience in the arbitration space before coming into esports and I think music and entertainment. What do you think about the writing in of suitable dispute resolution clauses into contracts?
I can remember when I moved to the Middle East to help set up Norton Rose's dispute resolution team out there, we would still quite regularly, in fact, see contracts that had the following as a dispute resolution clause: in the event of a dispute, the parties shall resolve the dispute amicably, full stop, end of clause. And I think that kind of, we haven't quite seen anything that pathological, but I think we have seen certainly some I would say, if I contextualize that again by, let's just remember who started a lot of these organizations. Again, it was gamers, and perhaps the governing law clause wasn't necessarily something that was given a lot of attention to in some of the agreements, even if it was in there. I think as part of that professionalization of esports, again, as the money comes in and we start to think about risk management and our organizations start to mature, you start to do things for a reason. You don't do things because, you know, you did it that way in the contract previously, and so therefore, you know, that's how you should do it again. You start to think about how you approach these issues, and that matters in relation to things like organizational values and all kinds of elements. Even why it is that you employ your players in a particular country, for example, maybe something that hasn't had a great deal of thought previously, but is now a key issue. I think in relation to esports now, we're starting to decide why it is that we're going along a particular line. My experience, as you mentioned, arbitration, I as a sort of practitioner, favoured LCIA arbitration clauses. In part, that was because the DIFC in the Middle East, which those of you are familiar with, the LCIA as an organisation will know that in the Middle East, the LCIA DIFC Arbitration Centre has some specific advantages to enforcement. I think LCIA has good bench strength in terms of the arbitrators it can bring to bear. Their expertise is helpful. But that's not to say that we don't regularly consider other bodies, and specifically those that are specific to sport. And I think what we haven't had yet is somebody ask for that on the other side. So a player to say, I specifically want a sports-oriented body to resolve our agreement. That will change, I think.
Andy, thank you very much. And I think happily that answers a question that we've just received from one of the sports arbitral institutions rather neatly. So let's move on to the question of data protection, and we'll take some views from Amelie and from Stephanie on this, of course, as well. One of the points which, legal points, which is going to affect esports, of course, is the international transfer of data, but also the transfer of special categories of data. It mustn't be forgotten that the pinnacle of esport performance may be when you're about 16. Andy will correct me if I have that wrong, but certainly very young. So there's a growing market, rather as in cycling, for biodata, for performance-related data, data which shows that a young player is or is likely to be prominent. And of course, that data, one can readily imagine, will feed into sponsorship agreements and the provision of certain products for that, the monetization, either for the team or possibly for the esports participant, him or herself. So special category data has got to be watched. Of course, anyone who's familiar with data protection will realize the significance of that. Explicit consent is required. Explicit consent is a slippery and difficult matter to obtain and to retain. Any consent is, of course, revocable. And the word explicit has been interpreted in European Union language to require fully informed consent. And therefore an appreciation of risk. For example, if there are tournaments played in China or places like that. Now, I was going to try and bring in here either Amelie or Stephanie. What are your thoughts on, for example, the bringing in of data? We're going to come to safeguarding generally in a moment. Stephanie, what are your thoughts on that?
Just on data in particular, you mentioned sort of international transfers, and what struck me when we were planning this webinar is how you actually trace that international transfer of data in the context of a digitalized community. I don't know whether Andy has any direct experience with this, or Amelie, but in terms of when you have a player based, for example, in the UK, the developers based in Southeast Asia, the tournament organizer is in a third country, how do you go about and actually map how the data has moved outside of the EU?
Goodness me, that's a good question. I think particularly when a lot of the services we utilize are cloud-based, right? So that brings in a kind of another layer of complexity. And also, I think there is a general trend in tech, you know, to move fast and break things, as the saying goes. And that doesn't always necessarily respect, let's say, legal boundaries when it comes to the sharing of data. I think social data is a really good example of that, where social data and social metrics that might be tracked by a SaaS tool, which do comprise personal data, are not always well tracked. I know that we've had conversations with some of the platforms that we use to exchange data as a business to see how they assess that. So rather than necessarily try and say, okay, this point is going, or this data point is going from here to here in the business, to look at the highways through which we process the bulk of our data and effectively try to treat those as the main pieces to be locked down from a risk management standpoint, and then start to get more granular on specific items of data. So how do you ensure that we track this through in a way, and how do we have the relevant consents to ensure that's done, with where necessary, additional proportionality tests, making sure that we're not, if we're processing data, we're only doing it to the extent required, we're and so on. Don't forget also we run sorry, that wasn't a fully satisfactory answer, but it's quite a complicated question in terms of how we track everything. Don't forget we also run a apparel business. We also run a hardware business in addition to our pro gaming line. Those things are in-house, whereas in many sort of traditional sports teams, they're often outsourced. So we're also managing customer data.
So taking in a standard commercial situation, you'd be advising your people to, first of all, to investigate there's an adequacy decision, then in the hierarchy look for adequate safeguards and possibly an explicit derogation if necessary under the GDPR. Now, standard use would be in standard contractual terms, i.e. those that have been approved by the European Commission. They're not yet being approved by the ICO here in the UK. Is this something which esports teams are looking at? Or do you rely on consent, for example, to provide data which goes to the PRC for a tournament? Yeah,
we rely on consent. So I think, look, as a first position as an organisation, we don't want to do and I'm sorry to state the obvious, but I think this can be novel in some context. We don't want to do anything with data which hasn't been specifically approved by the data subject, right? So I would almost rather, I'd almost rather overdo it in that regard. And I think if you look at if I was to show how even our privacy policy is developed, we've really tried to go out of our way to explain to customers how the data is being used, to explain to our players how the data is being used, particularly in circumstances where sometimes the players don't themselves particularly care about the value of that data or how it's processed by the organization. This goes to that maturity piece I was talking about earlier on. And we've gone from a position where the players would sign contracts, not necessarily with Fnatic, but sign contracts, handing over all of their intellectual property, personality rights, and so on for basically zero consideration. And just ideally, somebody would monetize that. It's kind of ideally not. To much more granularity in that, and that also brings additional layers of attention to what's happening with the information that I provide to you as a business. How do you as a quality organization ensure that my rights are protected in that regard?
Right. Let's move on then to more general rights, safeguarding rights. That's a link, particularly for special categories of data. Stephanie, yes. Obviously young players, international environments, lots of money, potential bonfire here. What are your takes on the developing areas that we're going to see in safeguarding?
Well, I think it's interesting, and it ties into Andy's point earlier about risk management. Because I see it with safeguarding. Safeguarding is principally concerned with detecting risk and then mitigating that risk. And I think in the conditions of gaming, they are particularly ripe for grooming of young players who, as far as I'm aware, get under the age of 15. So I think in terms of an esports team's responsibility towards those players, I'd be interested to know what Fnatic are doing to try and, detect those risks in this digitalized space and mitigate it.
Yeah, so for me, the number one risk in esports, principally because, and quite rightly, if it was shown that we had failed to meet our duty of care in relation to young people while they were on our premises or interacting with members of the Fnatic team, that would be an existential threat to our business. Again, an area where I don't think, very much with, again, with traditional sports, nobody gets into sport necessarily to deal with the downside of these things, or let's say the darker side of sport. And we've seen in football that unfortunately sometimes these things can get swept under the carpet for that reason. People don't feel appropriately qualified to deal with things, or just don't want to handle the consequences of what their gut feel is maybe telling them about somebody that's in the team. With esports, one area where we get to benefit from the learnings from traditional sport in these areas is, of course, on that these issues will arise if we don't do something to tackle it. And we've been very lucky to work with UNICEF on this issue. And again, you can find out more about that by just Googling Fnatic UNICEF. We've talked about this quite a lot because it is important, and we're trying to use the size of our organisation. If Fnatic can't tackle something like this and meet it head on, then who will, kind of thing. I would say it's a movable feast. We're going from zero in terms of safeguarding structuring in real terms. I mean, there may be policy there, for example, but is it being effectively implemented? Do the people who are dealing with minors, particularly on social media, which is where the majority of the conversation happens, which is the difference between us and traditional sport? All of our outreach pretty much is done through social media, so it's inherently harder to have visibility on some of those things sometimes, particularly when they're not conducted using work devices. We're starting to work out how to wrap that risk, and I think we'll move forward on that. But yes, there is complexity there. Yes, we are seeking to tackle it. I think we've had recently, as a matter of public record, moved out a coach who had sent some messages which were described by Reuters as being of a paedophilic nature. I think that's correct, to some fans. No tolerance, that kind of thing, of course. And again, we're able to work with the authorities to kind of do the right thing in relation to that. So we're learning. I think we're trying to approach it in a humble way and not think that we have it captured, because at the moment we definitely don't.
Now, we've got a number of viewers who are involved in professional football, one or two in Premier League clubs who have specific involvement with welfare and safeguarding in their clubs. Stephanie or Amelie, what would be your comments to them about why esports may be special, or where the risks are for esports over perhaps, say, a professional football club?
Well, as I see it, I think one of the difficulties with esports is the environment within which the risks could occur. So I've spent some time advising independent investigators who've been commissioned by national governing bodies looking at safeguarding allegations in traditional sports, so to speak. And often those investigators come from a police officer background or a local authority designated officer background. And as I see it, those individuals, whilst very well placed to investigate a traditional sport, might not be so well placed to investigate in this digitalized community. So I don't know if you have any thoughts on who might be well placed to undertake such an investigation when issues do arise.
Amelie, do you have anything that you would like to add on who, for example, might be have the most relevant skill set for that and do the best job?
In terms of, well, the first thing that comes to mind sort of slightly before answering that question is that a lot of the risks are happening on private messaging, the stuff that has come up most recently in the press. There was another analyst not related to our organization, but within the League of Legends community that has recently been banned for a certain period of time from taking part in the LEC. And I think a lot of those things are happening on private messages, which makes it incredibly difficult for us to, or any organization to mitigate the risk in that respect, because we don't know it exists and there's no way of us finding it out. In terms of people who would be particularly well placed to investigate, I think it would have to be people who certainly come from the industry or have a better understanding of how contact is made, where the risks exist. And it's not, as Steph said, it's not in the places that you would necessarily think in relation to other sports. It's all online, it's all via social media. So yeah.
Yeah, I mean, I think structural risk management is poor at dealing with this, but right now, again, as I mentioned earlier on, it really is important to contextualize everything in esports with the following statement. We are working out how to do this as we go along in a developing ecosystem with the first digital first sport, and again, the inherently international, inherently digital nature of what it is that we do does mean that some of those even structural responses to these kind of things can be very difficult to implement. If you then have the behavioral overlay on top of that, just as with sport, it just adds an extra layer of complexity. So I really want to emphasize we're approaching this in the most sort of progressive way that we can, but also the most humble way that we can, because I think the moment you think you've got this kind of thing cracked, that is the moment when you are going to fall over as an organization.
Well, thank you for that. Let's move on a little to the connected area of integrity, betting, gaming, ultimately doping and match fixing. Now, these are big and wide topics that we certainly don't have time to discuss in a lot of detail. But I would be interested, and I hope our participants will be interested to know where you think, Amelie and Andy, the real risks are. Is it match fixing, or is it doping, or is it corruption of young and vulnerable players with large aspirations?
Well, probably all of those things. I think it's interesting, we've seen examples of those happen in the relatively recent past. So there is a disciplinary matter going on at the moment with a team called Newbie in China, which has previously won something called the Invitational, which is the biggest tournament in a game called Dota 2, which you may well not have heard of, but has a phenomenally large prize pool, tens of millions of dollars. And so it's a big deal that they ban sport and or players are banned permanently from Dota. And remember, the developers own the games. So unlike football, if FIFA bans you from playing football, being involved with football, you can still have a kickabout in the park. That's not true of digital sports. Once you're out, and you're not coming back in. In relation to doping, we've seen a player advertising, again, not a Fnatic player, advertise, and advertise is the right word, steroids on his Instagram stories. Certainly my favorite way to get information about steroids, and push those out to his followers. Steroids not on the ban list from it was about substance, no performance in terms of esports. But again, for me, an absolutely no compromise, zero tolerance if that has to happen at Fnatic.
Amelie, anything you'd like to add to that? Sorry. Anything you'd like to add to that, Amelie?
I think Andy covered it off pretty well, actually.
That's great. Stephanie, anything you'd like to add to that?
No, I think that's everything. Thank you.
That's great. Okay, good. Well, in the remaining time we have, what we're going to wrap up with some further comments on dispute resolution. We touched on some of this during the contractual issues discussion. And Andy described, obviously, the preference and the history of arbitration here. What I'd like to do here is just talk a little about how this may develop. Tiered dispute resolution clauses, mediation clauses, the international nature of this business. All this would tend to suggest that conventional litigation is not going to be appropriate. Where you've got disputes that involve, for example, Chinese entities, you've got questions there about applicable law. Many government entities in China, and often it's difficult to determine what is a government entity in China, will insist on nowadays on Chinese law being applicable. There is no reciprocal enforcement of judgments order between this jurisdiction and China. And therefore, it's likely that arbitration will remain the preferred choice for dispute resolution. In my view, mediation has a real place in this business. It's inevitably about maintaining relationships, particularly the close connection between the commercial relationships, sponsorship, and other relationships. So I can see that tiered dispute resolution clauses are going to be popular. They have their own difficulties. We've all seen them, particularly when they're overly tightly drafted. One of the biggest mistakes being to specify a certain mediator or not to provide the room which is required in order to make sure that the tiers of the dispute resolution can be successfully jumped. Stephanie, you've had some studies on some of the very prominent cases that Andy mentioned earlier involving one of the gamers. Tell us a little bit about that and what you've learned from that.
Yeah, so I've been following the TIFU and FaZe litigation in the US. Interesting case, concerns a gamers agreement in what Andy described in our last seminar as the Motown era, where there was a real power imbalance between the player and the team. In terms of the litigation to date, essentially, TIFU reported FaZe Clan to the Labour Commissioner in California. He also started proceedings in California, whilst FaZe Clan commenced proceedings in New York, given there was an exclusive jurisdiction clause. I'm not going to go through the details of the proceedings because they have become quite protracted, but essentially following a motion to dismiss, given that we're in America, the FaZe Clan were successful, and what has essentially happened is the dispute will be determined in New York, provided that the non-waivable statutory clauses governed by, for example, the Talent Agency Act will be applied by the court in New York. So it's kind of interesting in terms of the exclusive jurisdiction and applicable law point. But with regards to what that dispute tells us about esports, what is really interesting is the extent to which it's been played out in the public domain. So even looking at FaZe Clan's statement of case, they actually look at TIFU's increase in Twitter numbers and Twitch followers since the litigation commenced. They also had an issue with him sharing the gamers agreement and giving his views on the litigation on YouTube. So in terms of litigation, it raises questions about the contempt of court and that sort of thing. The other case I want to very briefly touch upon is the case which has been brought by the Esports Integrity Commission against Amelie Draper. You might have noticed that he appealed the decision, which was in relation to him cheating during Counter-Strike. The appeal was actually released yesterday, and he managed to get his ban reduced. What I think is really interesting about that is if you look at the rules applicable to that particular tournament, they have very, very strict confidentiality provisions, which is interesting given that with other sporting disputes, there clearly is a public interest element in these proceedings. So how do you reconcile the private nature of arbitration with that public interest element? Do you have public hearings or do you have a published decision? How should it work?
Thank you very much, Stephanie. And we're coming towards the end of our time, but we're going to be faithful to our time because we've all got many, many other things to do, and I know that there's many other webinars. We've received quite a number of questions coming in the last few minutes in particular, and I'm going to offer the following 4 or so to my colleagues on the panel. The first is this, and this one, without doubt, is for Amelie, because it's an anonymous question, which asks, how do you as a young lawyer get into esports as a lawyer? I think you may be one of the first, if the only person doing a training contract in this very specific space. Is that right?
As far as I know, yes.
So how do you do it? How do you go about becoming an esports lawyer?
I was working previously at a legal platform for startups, and so sort of similar in-house type work, and Fnatic were recruiting for a paralegal, and so I joined the team as a paralegal and I'm not a gamer, I had no background in esports, so it was more about the sort of breadth of experience of doing that in-house work, because the job is incredibly diverse. It's fundraising and pro gaming contracts and sort of just the day-to-day management of a business that also makes apparel and gear. So it's definitely not just limited to the esports side of it. But yeah, that's my very long-winded answer to that very simple question.
It's very informative. Stephanie, a question for you here, possibly also for Andy. One of the questions here asks whether there are any uniform policies out there regarding safeguarding. Is it up to the teams to go back to first principles, do it themselves, or to other sports, professional football or athletics or gymnastics or the like, and borrow from them? How do they and should they go about it?
As far as I'm aware, there aren't any international agreed rules. Whereas in traditional sports, maybe the national governing bodies would set the rules and the clubs would incorporate those rules into their individual contracts. With regards to the international federations or the equivalent in esports, there certainly are some contenders, the International Esports Commission and the Global Esports Commission, although it has some interesting links to a Chinese company. And potentially in the future, they are the ones that could lead on setting the rules. But as it stands, it really is, as far as I'm aware, sort of Hobbesian state of nature, and therefore it really depends upon individual organisations setting the rules.
Yeah, I mean, we're pushing this. So in those games where the ecosystem is still developing, the sort of the core of the planet is still forming. We're pushing very hard as an organisation for there be more specific rules around safeguarding. As of now, those developers with the ability to attach strings to participation, like Riot, are in a fantastic. They've already shown that they're prepared to move the needle forward in terms of things like the status of employees and minimum salaries and those kind of things. So this will start to, as they put in those foundational layers of rights for employees, I think they'll start to see the importance of safeguarding. Certainly, again, we're lobbying as a team to push that, and they will start to push these things forward, and those things will start to be a best practice within esports begin to form, and then smaller organizations will be able to jump on that. So I would say ask that question in 3 years' time, because I think by then we'll have a better answer.
Fair enough. Well, I think we've got time for 3 more questions. One of the questions asks about alcohol sponsorship and whether there are any binding or other forms of guidance as to whether or not teams should accept alcohol sponsorship. What's the position on that?
So it depends on the game, is the short answer. So again, always the first question in esports, which game are you in? And that's going to determine many of the rights and obligations, and the same is true here. So within Riot, again, we're using them because they're the most structured example. We keep on coming back to them, but that is the position. They prohibit association of alcohol with esports. They put it in the same category as weapons and cryptocurrencies and various other things which they deem unsavory. In another part of the Riot universe, so we play in the LEC, which is the European competition, the American equivalent to that, there has been some movement in relation to allowing some associational rights between alcohol and esports. So, that's something to watch out for. In other games, the same sort of rules are also applying. We've done some work as an organization with alcohol brands, but that has absolutely not had any association with any games. We like to draw a nice big bracket around that. So yes, the short answer is it depends on the game.
Well, as I said, two questions there. One is this: what about intellectual property rights? One of our guests asks whether what are the prospects for wresting the overwhelming control of IP rights away from the publishers? I think we can detect his point of view.
Yes.
What are the prospects and where do the rights really lie?
Well, I mean, this is the competition law. This is the interesting. If you're an antitrust nerd, this is where you should be looking, because the question of whether or not IP can confer dominant position, I think, is an interesting one in esports, given that the games are at the heart of the dominance that is being pushed out by some of these teams. There's been some interesting arguments about this in relation to a game called StarCraft in Korea. Again, not necessarily an area of interest for us as a team, but I think that's something to watch. The question is, I suppose, or the assumption there is that we want to participate in that IP in some way. Actually, we have our own brand to build, and also our players have their own brands to build. And I think one interesting area for football will be the first crossover streamer in that sport. Streaming's so important to brands. We have our own channel on Twitch. We have our own affiliate network of streamers. They're so important to building the top of our commercial funnel. And our brand, we care about building our brand, not taking IP off other people.
Thank you. Well, the last point I think I'll take, because it makes some sense. One of the questions is, how important is it for an arbitration clause to specify the experience of an arbitrator in this space? So, for example, CAS or the LCI or any other institution, Sport Resolutions UK, one could name many. How important is it that the clause specifies it? Well, my view on that is that the clause shouldn't try and specify it, because that builds in its own problems. However, what is important is that all institutions provide for input of the parties when arbitrators are selected, whether it's a sole arbitrator or a panel of three. And it's at that point that the parties should explore, firstly, whether the prospective arbitrator has experience in sport. Secondly, whether he or she has experience in tech. And third, ultimately, whether he has experience in esports. So those are the questions. We're very grateful to you for staying with us. I can see the participants, no one else can. The attrition rate has been very low indeed. Thank you very much indeed. This webinar, as I repeat, has been recorded. It will be available on our website. Also, courtesy of the kind efforts and support of one of our junior members, Daniel Kozelko, it's been live tweeted throughout. So if anyone wants to pick up that thread, they're more than welcome to do so. The handle's on the holding slide at the start. I'd like to thank first, obviously, my colleague Stephanie David, but mostly our guests, Amelie Draper and Andy Cooke. Thank you very much indeed for providing the insight to the participants from a real team perspective, and have a very good afternoon.
No problem. Thank you.
Thank you.